As an attorney, one of my biggest fears is having someone walk into my office with a business dispute, and when I ask them for their governing documents, they say, "Oh, we never signed any." I've heard every excuse in the book. This is my spouse, this is my best friend, oh, I didn't have time. The problem is that there will always be a need for bylaws, for articles of incorporation, and for shareholder agreements. Whether you're in a dispute or not, any investor who's looking at your business wants to see how your business is run, and they tell that based on the bylaws and the shareholder agreements. Further down the road, if you ever have equity disputes, oh, I did more work, I put in more money, the shareholder agreements will always be the controlling factor in determining who actually owns what portion of the business. That's why today I'm going to give you a brief overview of all the documents you need to protect your business for the future. So what are the documents I'm talking about? Well, generally there's between 2 and 4 documents that you need to take care of. The articles of incorporation, the bylaws or operating agreements, the registration application for your business, and the shareholder agreements, membership agreements, anything like that that you have between different owners of the business itself. When I say articles of incorporation, I want you to think the Declaration of Independence. Your articles of incorporation are the foundational documents where you say, hey, I am no longer just one person, I am an entity recognized under the law. So what you need to put in this document is essentially the name of your business and the type of business it is. Is it an LLC? Is it an Inc? Is it a PLLC? That sort of thing. You need to put the state on notice that you are a separate entity and this is what kind of entity you are. You also need to tell your state where they need to send documents to notify your business of certain things like your annual fees. We talked about this in the last video. That's called a registered agent. Most companies also opt to tell the state what the purpose of their business is, such as our business is to open a storefront where we sell groceries. Most states want to know generally what you're doing with your business. This usually has no legal binding effect unless you are a nonprofit in which you have to state in your purpose certain provisions under law. You should also tell your state how much equity you intend to give out. I intend to give out 5 billion shares of stock, that sort of thing. Also in your articles of incorporation, when it comes to equity, you should tell your state if you have different classes of equity, such as founder's equity and shareholder equity. This is the proper place to put in if you are separating different classes of equity for voting rights later on. In the power section of your articles of incorporation, most companies just opt for all powers available under the law. However, this section is very, very important when creating a nonprofit. I would suggest you speak to an attorney to draft your articles of incorporation if you're intending to start a nonprofit. Where the articles of incorporation are the Declaration of Independence for your business, the bylaws are like the constitution for your business. Bylaws are typically separated into articles which govern each body of the corporation itself. If you're an LLC, your bylaws are often called an operating agreement, but they're generally the same thing. In your bylaws, you want to tell the general public where your registered agent is and where your principal business address is. You should also tell your shareholders when the annual meeting is, how special meetings get called, how they'll expect to be noticed for those special meetings, and what voting rights they have. The voting rights for shareholders is how you stay in control of your business in perpetuity. Remember how I said that you can create different classes of stock for your corporation? Well, this is where it's important. You can create a class of stock that has more voting rights than other classes of stock. That way, even if you get large capital investments, you can stay in control of your business. Shareholders' main job is to elect a board of directors every single year or every single time there's a vacancy. Within your bylaws, it's also important to say how your board of directors will get elected, what powers they have, how many board of directors need to be available in order to vote on something, when will a unanimous board be necessary, and their term limits. It's also important to specify What happens when one of your directors is acting poorly? By acting poorly, I mean he owns a business that's directly in competition with your business, or he's not acting in good faith towards your business. Deciding this now will save you a ton of headache in the future. You should also within your bylaws specify what officers you believe will be necessary for your corporation. Most companies have a CEO, a CFO, and a corporate secretary. However, if you're a tech startup, you might want to consider having a CTO, or potentially a Chief Officer of Marketing. Once you have your bylaws and articles of incorporation, it's time to register your business. How to register your business varies by state, but generally they will require at least your articles of incorporation. However, other states want both your articles of incorporation and your bylaws. Another requirement for registering your business is your business has to have a unique name. So make sure that when deciding the name of your business, it's not a name that's already been taken. If you can't get the name you want, there are solutions for you. For instance, if you want to name your business Greengrass Incorporated, and Greengrass Incorporated already exists, you can name your business Browngrass Inc. and then file a doing business as a DBA as Greengrass. Again, you may have to indicate on your application form what kind of entity that you are creating. Certain entities require additional evidence, such as professional licenses for a PLLC. And also, typically there's a filing fee, which is to be paid by check. Never send cash in the mail. You might think that once you have your business certificate, you're done. However, there's another really important step. If you have multiple owners of your business, such as multiple shareholders, multiple members of an LLC, it's very important to come to an understanding now and get it into writing for how the business will interact with them. Let's say you get into business with your brother, and your brother's supposed to do all of the labor while you contribute capital. You want those obligations written down and clear between you guys before you start working. And how is your brother being compensated for his labor? Well, in the form of consideration. Typically, consultants that provide labor to a brand new business get compensated in the form of stock. However, it is generally never advisable to give someone a lump sum of stock at the very beginning of your business. That's where the concept of vesting stock comes in. Instead of giving your brother 50% of the business up front, you want to give him 10% every single year as long as he keeps working. That way, after a year, he can't leave the business and still own half of it. What about for you who's providing capital? Typically, people who provide capital at the very beginning of the business sign what's called a restricted stock purchase agreement. A restricted stock purchase agreement ensures that the person buying the stock can't just go out and sell that stock tomorrow. This is important because you need to know who owns what portion of your business at all times. Typically, if you have an LLC, you will sign one document called a membership agreement or an operating agreement. This one document will account for all of the obligations and all of the equity for all members of that LLC. It's essentially your bylaws and shareholders agreement all wrapped into one package. Both the shareholders agreement and the membership agreement should account for what happens to that person's interest in the company should he act poorly. Again, by acting poorly, what I mean is acting in their self-interest to the detriment of the company, or opening a new business that's in direct competition with your business. I hope this video gave you a good overview of the required documents you need when starting your own business. A lot of these documents can be a little bit complicated to draft, so I would encourage you to go out and find an attorney to draft them for you. This video was not intended to be legal advice, but if I can give you some human advice, even if you can't afford an attorney, try to draft something. Because 5 years down the line, 10 years down the line, you're going to really appreciate the fact that you tried to draft something. In our next video, we're going to dissect a few contracts to see some common provisions you may find in a contract you are required to sign or a contract you are required to draft. That video will give you a general overview of what to expect in contracts and what needs to be in there. My name is Mario Latona, and you've been watching The Law Mogul.